Welcome again to Frenemies, the series where McGuireWoods intellectual property and data privacy and security teams help marketing and legal departments understand each other, work together, issue spot, and maybe go from being frenemies to becoming friends. If you listened in on Season 2, Episode 1, you'll recognize me as Brad Newberg, a partner in McGuireWoods IP practice. I focus my practice on copyrights, trademarks, domain names, trade secrets, dilution, and unfair competition. If you haven't had a chance yet to listen to the first episode in Season 2, I do encourage you to, as today's topic does build on what was previously covered, although you can still watch them out of order if you like. You can access Episode 1 on McGuireWoods' website. Today has the episode of The One with Sharp Elbows, Protecting and Enforcing Your Intellectual Property. As my practice focuses on the copyright and trademark realm, we'll be focusing on those two areas of intellectual property. We'll talk briefly about what it means to have a copyright or a trademark and how to protect them generally, and then we'll launch into the specifics of the pros and the cons of various enforcement mechanisms. It's very important to keep in mind that intellectual property issues can be very fact-specific, so you should not hesitate to contact your in-house or your outside counsel with specific questions. So let's jump in. What is a copyright? A copyright affixes to any creative work that has been fixed in a tangible medium. Now, the tangible medium part comes up mostly for if we were having a conversation and that wasn't recorded or written down in any way. Nothing in that conversation would be copyrighted. But more importantly, the focus is on creative expression. So copyright cannot protect ideas, it cannot protect facts, and it cannot protect something that is functional in nature. It's creative expression is what it does, and creative expression can be a book, it can be a photograph, it can be architectural plans, and so on. It can protect software code, for instance, but not what the software does. Another example I could give you is that you and I could both write a biography of, say, Abraham Lincoln, and we could both talk about the Gettysburg Address and the facts of that particular day, but you cannot, however, cut and paste my particular paragraph describing the day and use my specific expressive language. Even instruction manuals can be expressive if there are multiple ways of expressing something. We can all use the same facts, we can all use the same ideas when it comes to copyright, but we simply cannot use the same expression. Now, a lot of people think that to have a copyright, you must register the work with the United States Copyright Office, or that you must put a specific copyright notice on the work. Well, neither is true. Such formalities have not been around in the law for quite a while. Copyright exists the second pen goes to paper or you click the button on your camera. However, notice, for example, is helpful. For example, having your name and the year and the C in the circle, just because it alerts people to where they should go if they want to get a license or who they should contact if they have questions. And it lets people know that you're serious about your enforcement and that you're claiming ownership. It can also create additional claims if one were to remove your notice from your work while they're committing copyright infringement. So if they copy your work and remove your notice, that can actually create additional claims. Registration, on the other hand, even though it's not required to have a copyright, is very important. In the United States, you cannot sue someone on a U.S. work unless you have first registered your work with the Copyright Office. Also, the big sticks, as I like to call them, of copyright law, which are statutory damages and the ability to get reimbursement potentially on some of your legal fees, are not there unless you have registered your work right away, promptly, or at least before the infringement occurs. Now, registration is very inexpensive, usually costing no more than $50 per work, sometimes as little as $35 per work, and the existence of even group registrations for things like photographs. And it's extremely quick to do in that it takes just a few minutes with an online form and attaching the work on the U.S. Copyright Office website. And you do typically get the registration back within a couple to a few months, although there is an expedited option available. For instance, if you were going straight to a lawsuit, you can put in and pay a little extra and get an expedited treatment. Really, anything you think of as important to your business in terms of content should be registered. The other good thing about copyright, once you get it, is it lasts for a really long time. 95 years from publication, to the extent it's a corporation or a company that has a work for hire, or if it's an individual, it's the entire life of the author plus another 70 years. So it does last quite a long time. Now, trademarks have a lot of differences from copyrights, and sometimes people use them interchangeably when they don't know intellectual property. Well, the copyrights for creative expression, while trademark is very specific about your brand. And trademarks, unlike copyright, I said copyrights are around as soon as you put pen to paper. Trademarks are not automatic at all. They are dependent on your use and your timing, and they only work if they serve as a source identifier for your goods and services. Trademarks are anything you can use consistently and uniformly as a brand, and you must do both. You can't use something once or twice and say it's your trademark. You can't constantly change it up and claim it's an identifier for you. Now, you can do offshoots that build upon the brand, but even that needs to be consistent with the brand. Most people think of trademarks as words or logos, and they are. And I should mention that a logo is often artistic, so a logo can also be copyrighted. But in addition to marks and logos, trademarks can also be slogans or colors or even sounds like the Intel chime or even the trade dress on your store. You can see here on the slide an image of a store that just about any tech consumer would recognize as an Apple store. And so if you have something that is really distinguishable and really identifies you, that can be a trademark or protectable trade dress. Now, trademark rights do exist as soon as you start use in the marketplace if the mark is distinctive enough so that the marketplace will recognize the mark as an identifier for you as a brand. Other marks are a little bit more descriptive. They are closer to what the good actually is, and so they need to be developed over time. And to have protection, you will need to prove that there's secondary meaning in the marketplace, meaning that you actually have to show that customers look at this particular mark as an identifier for you. Trade dress, such as how your store looks, as we discussed, or your packaging, that must always prove secondary meaning. You never get that automatically. You have to prove secondary meaning to have protection for that. And when I say prove or show secondary meaning, that's typically done by showing a court or the United States Patent and Trademark Office that you have been using it for a significant amount of time, usually at least 5 years, and you've been using the branding consistently with a lot of sales and marketing attached to it. And so you show the USPTO that, or in the case of court cases, you show the court that. You can also use market surveys to show secondary meaning. Now, trademarks, copyrights, we said, last a very long time. Trademarks don't have an end date at all. You could probably think of various brands and trademarks that are well over 100 years old. So as long as the use is continual, trademark rights will be continual as well. Now, we typically recommend registration of any brand you think you'll be using for an important market line or certainly a flagship brand. Registration provides notice to others. Again, you can have a trademark without a registration, but it provides notice to others, and you get various presumptions in court, as well as a higher likelihood that if you are in a court case, you can show bad faith of the potential infringer because there's more likelihood that they knew about your mark and knew about the way you protect your mark and what you claim it for. Typically, when you do a registration, you will do a formal trademark search first to see what the marketplace is like, to see what else has been registered out there, and whether your proposed mark is likely to be registered and is not infringing on others. We discussed this in more detail in prior episodes of Frenemies, so you can go back and if you want more information on trademark registration, you can look at those and hear those episodes. You can also register marks on an intent to use basis. So if you're planning on a big launch, you can actually put in a trademark application saying that you intend to use it. And this gets you some timing advantages over someone who starts use after that date. And after you've shown your intent to use that mark, a competitor can't just hear that you're going to use it and try to jump in before your upcoming launch. While we've discussed the proper use of a trademark in other episodes, I think it's important to touch upon the best ways to make sure you're taking care of your trademark rights. You need to make sure that all of your customers in your marketplace, your consumers, others, they know you're using as a trademark. Now, that seems obvious, but it really requires consistency and it requires vigilance, which is why many companies have branding guidelines for people internal as well as partners so that they show exactly how their mark should be used from the size to the font to the way they're offset from other words. The big takeaway I can give is that a trademark needs to be obviously a trademark to anyone at first glance. That consumers know that this is different because it isn't just part of text like any other words, but you have the different sizing or capitalization or colors. Perhaps most importantly, that you use the TM for unregistered marks or SM for service marks just after the mark, or the R in a circle just after the mark for registered marks. Now, if your mark is listed on a web page over and over again, you don't necessarily have to put the TM or the R every time, but it is recommended if possible, and you just need to make sure it's very clear, it's on the page prominently, and you're using it fairly consistently. Now, you should also make sure all your marketing people, all your licensees, all your partners, all your manufacturers, that they're using your marks as a trademark for you. And one of the big things you need to think about is a brand is a brand. It's not the name of the good. It's not the type of the good. Because if it's what the good is called, it can't identify you. Now, the good has a name, whether it's toast or chairs or consulting services. That's the noun. A trademark cannot be the noun. So we have some examples on this slide, but the point I make is we all dream of a time when our brand is so famous that everyone sort of uses it interchangeably with the product, but that actually can be the death knell for a trademark. So you want to make sure your mark does not become the generic name of the good or the service. I will, as a shout out to someone else, to other people here, there's a great video online that the legal team from the brand Velcro have put out that is both hilarious and educational. So I highly encourage, if you want a good laugh and some education, you can do a Google search for it. So let's now move to what you do if you see someone infringing your work. There are different types of infringement, obviously, copyright and trademark, and then I'm going to go into contributory infringement. The copyright infringement is someone copying your work, obviously, or using something substantially similar, or making a derivative work, something new based on your work using parts of it, or public display or public performance without permission. Now, trademark infringement is similar, but it's that they're using your brand or something similar to create confusion in the marketplace and make it appear as if you are related to the infringer in some way or sponsored in some way, or that their goods actually emanate from you. And contributory infringement is someone helping others commit infringement, either through inducement or offering services that help the infringement, or directly profiting off the infringement when you have the ability to stop it. Now let's talk a bit about the defenses you might hear to infringement claims, because that's also going to give you an idea of how fact-intensive this can be, which is why it is important that whenever in doubt, you get legal advice, whether internally or externally, on the best ways to proceed. For example, in copyright, you can't own something that has absolutely no originality. So even if it's copied, if it had no originality to start with, you can't actually sue someone because you don't have the copyright over something that has no originality. Now, I will say that under the law, though, very little originality is required. Even if 1 million different people have taken pictures of sunsets, my particular photograph of a sunset is my photograph. It belongs to me. It might look only slightly different from the other million sunset photographs out there, but that exact photograph is mine. Now, fair use of the defense has a whole bunch of different factors involved, but typically involves taking as little as possible as is needed to get a very specific point across and not affect the marketplace for the original work. And while the statute of limitations on copyright is 3 years, each new copyright infringement is subject to its own statute of limitations. So if someone keeps making copies of your work, they're going to keep resetting the clock for each of those new infringements. You're not going to be able to go back for the old copies, but each of those new infringements typically are going to have their own statute of limitations. And I'm talking generalities, obviously, here. So each of these things can be very fact-intensive, depending on whether you knew about the infringement and had discovered it and should have, and so on. Now, for trademark, the main question is going to be confusion. So if there's no likelihood of confusion, perhaps because the mark's not that close, or it's totally in another industry, or it's very clearly comparative advertisement, then there'd be no infringement. Or what if your trade dress is functional, so that competitors actually need to use it it's in order to compete fairly? Or what if nobody really recognized your company as owning the brand, so there's no real source identifier, and you obviously need the trademark to sue for trademark infringement? So I'll just touch on contributory infringement briefly, but it's so that you're aware both how not to be a defendant, as well as whether you can go after other companies. Contributory infringement typically requires that a company has actively helped or induced others to infringe. However, there's another part of contributory infringement, and it's often found in contributory trademark infringement for the most part, and that's when you continue to supply a good or service to one whom you know is engaging in trademark infringement. So if you're on notice that by providing this service to a third party, you're providing the means for that third party to commit infringement, then that might give rise to a contributory infringement claim. Now, shifting gears, there's also a why do you enforce question. Now, the law generally understands that companies have limited resources. They can't necessarily go after everyone, and often you don't lose rights against one person just because you didn't go after a different person. Now, copyright's certainly typically that way. Trademark is a little different. Because trademark requires that your mark specifically be an identifier for your company, allowing others to use it will hurt the mark's ability to operate as an identifier. Sometimes companies have to work very hard to get back rights after they have let them lapse a little bit, or allowing a crowded field to emerge. We have an example here on this slide, an example of that being John Deere, which about almost 40 years ago now, in the early 80s, found that not enforcing severely diluted their ability to claim their color as a trademark over time. After a decision against them in the early 80s, they shifted gears and had to engage in a campaign of going after infringers, clearing out the market, and now courts have issued opinions where they respect the John Deere color as being a source identifier and enforceable trademark because they really worked hard to enforce that mark. So you want to make sure that you're enforcing it because there is an enforce it or lose it system under trademark law. And as I said here on this slide, we note again, enforce it or lose it. So you need to have some sort of system where you're set up to monitor and enforce your rights, and I'll talk a little bit about monitoring later on. But you want to make sure that you're doing things to protect your rights. Now, obviously, you want to be careful that you're not going after everyone that is making a fair use or comparative use or using your name simply to refer to you. It's got to be something that is confusing the public into thinking there's an affiliation that there isn't. Now, the two biggest factors in terms of how we enforce, why we enforce, whether you're going to enforce, are often the time it's going to take and the cost of actually enforcing. There are other factors. The venue is important. Your chances of victory are obviously important. And the type of public statement you want to make. And here we have a statement about public perception. The type of statement you want to make goes both ways. You want to consider your defendant. Is it a competitor clearly acting in bad faith, or is it someone who might have fair use consideration, or who is going to be highly sympathetic to the public, or is acting in a way that is not causing you confusion or really isn't causing you harm? I always tell clients you should always assume that any letters you write are going to become public fodder, might be seen in the press, might become viral, and you should always measure your tone according to the situation at hand, your potential infringer, and what you hope to achieve. Now, we're now going to talk about 6 of the most common ways to enforce your rights. The first is the well-known and simple cease and desist letter, where you clearly set forth your position, tell the other side what they're doing wrong, and tell them to stop or what it will take to make the situation right. Now, this can be used for any type of dispute. It's cost-effective. It may result in very speedy resolution. It may result in some sort of not only speedy resolution, but actually a settlement agreement where you lay out future rights. And sometimes another company will realize its mistake, will understand and wants to avoid litigation, and it acquiesces or works out an arrangement immediately. However, cease and desist letters are not a guaranteed response, or the response may be to pound sand. I will say that over the years, I have developed an immediate response to clients who want me to write a harsh cease and desist letter. And that response is basically, okay, we can do this. There's a good chance this will work, but what will you do if it doesn't work? Do not make threats that you're not willing to follow up on. If you promise someone that you will see them in court if they do not comply, and then they do nothing and you do nothing, you're actually only hurting yourself, because you've basically told them now that they can get away with the infringement, that you will cry wolf, and you now have evidence actually that you're on notice of the infringement and you failed to protect your rights. So make sure again that you're measuring your tone depending on what you are willing to do. Also, make sure you gather things like screenshots, evidence, things that could go away easily beforehand, just in case what the infringer does is doesn't actually stop, but takes down the evidence that you had, that was really good evidence, and they just tweak something to something you still don't like, but now the evidence is gone. So again, and finally, assume that the letters will be public. Do not send overly aggressive letters when they are not called for. Next, federal lawsuits. So the big hammer of intellectual property protection. Almost all intellectual property cases are handled in federal, not state court. Federal lawsuits are an almost guaranteed resolution of your rights and a public showing you're very serious about enforcement. And there's also the possibility that in various cases, you can get preliminary relief if the infringement is egregious enough. And of course, there's the possibility of damages, sometimes very large damages, especially where the infringer made a bunch of sales using your exact copyright work or using your brand on a specific thing that it's selling. However, federal lawsuits and lawsuits in general are very expensive, and they can take a long time to resolve. Some courts, really depends on the court as well. Some courts are known as being very quick, and you would get all the way through to summary judgment and potentially trial in less than a year. Other courts may take close to a year just to decide a single pending motion, putting everything on hold or in limbo for that entire time. Then there is, of course, the time aspect of your employees and the money it costs in terms of having your employees have to take focus away from their jobs to gather documents, as well as to be deposed, as well as to talk to lawyers. So there's always that to consider. Lawsuits should be reserved for the most important of disputes, or the ones where you clearly need to make a public response to protect your rights. Now, there are actions also that are very specific before the Trademark Trial and Appeal Board. These are called either opposition or cancellation actions. Now, they're solely related to trademark applications and registration, and it involves typically a mark being preliminarily granted or granted where you thought it shouldn't have, and it's affecting your rights or your own ability to get a trademark registration. Now, this is also a visible way to show you're serious about enforcement, and it's not as expensive in litigation, mostly because it is a very discrete issue, whether this mark should be or should have been registered. So it is a discrete issue, so it's not going to be as expensive or wide-ranging as litigation, but I still tell them to treat TTAB actions as litigation. I still tell clients to treat them as litigation because you still have document discovery, you still have depositions, you still have your witnesses having to gather these documents and get ready for depositions and give information. One thing they won't have to do is go to trial because TTAB actions are actually done all on the paper and depositions and such are submitted instead of bringing people to trial. Again, I'll note this is not an infringement suit. It only affects the registration of marks. So it doesn't allow for damages or the reimbursement potential of legal fees if you win, which, as I mentioned, is a possibility in copyright and trademark suits. Now, let's talk about domain names. When someone cyber squats or typo squats or otherwise uses your trademark in a domain name in an unfair way, that is very likely to be trademark infringement. However, they're also violating international rules about domain names. And sometimes all you really want to do, or the most important thing for you, is to shut that domain name down, or you realize they're in a foreign country and enforcement will be very difficult, and you think at least shutting the domain name down is something we can do quickly, easily, without having to figure out how to go after them in another country. So this is where the Uniform Domain Name Resolution Policy, or the UDRP, comes into play. UDRP filings are very quick, extremely quick, very cost efficient. Typically, they cost just a few $1,000s, including the filing fees and the legal fees. Typically get your resolution within just a couple of months, with the illegal domain name, if you win, being transferred to you. So the rules are very uniform among all the different what are called top-level domains, .com, .edu. There are some exceptions, but all the major ones follow these same rules. And the question is really limited to whether or not this domain name was registered in what's called bad faith, basically. They don't have a damages component. That's the only question. And it's basically an arbitrator who on paper is just going to see the complaint, see maybe the response and the reply, and just make a decision. So, you know, this is something you can do very quick, and it's done globally, which is a major advantage, but it is limited to this domain name only. And if someone pops up with a slightly different typo, you're going to have to start that over again. You may be able to refer to the prior decision, but you'll still have to file a new complaint. And I should mention here, we list reverse domain name hijacking. That's pretty rare, but it does show you want to avoid being over-aggressive because there is a claim that can be put against trademark owners called reverse domain name hijacking, which basically someone can file against you saying you're abusing the system with frivolous claims just to try to take away domain names you don't like, which actually aren't in bad faith or causing confusion. Let's talk now about takedown notices. There are takedown notices that some of the major websites and search engines have for trademark infringement. You actually go to their website, you can click on the forms, and tell them your issues, and you can do it that way. However, for copyright specifically, takedown notices can be an extremely powerful and quick and extremely cost-effective method, especially in the United States, which has the Digital Millennium Copyright Act. Basically, if you see an online infringement of your copyright rights, there are certain magic words, basically it's a list of half a dozen or so things, that you can provide to the host site or the social media site to say, I own this copyright, this is being used and infringed in this way at this portion of this site, and it must be taken down immediately. And this is sort of a no questions asked. The site host has to take it down typically within 24 hours, and it's just done. Now, you do need to have a reasonable belief this is infringement and not a fair use, and you're declaring everything in that notice is true. And then what happens is the person who did post the material has a short amount of time, a couple of weeks, to let the site know if they think that the posting was actually appropriate. It's what's called a counter notice. Now, counter notices are less likely than not. Typically, the stuff just stays down, but they can put a counter notice up, and then basically you have a short amount of time in which you can decide either to go after the person for copyright infringement in court or not. And if the answer is not, then the material will go back up, and that's how the DMCA, the process by which it takes care of it. But like I said, counter designations are fairly uncommon. Usually, if you've got a pretty clear infringement, you send a takedown notice, it gets taken down. Again, there's a whack-a-mole problem that someone could put it up somewhere else. You'll have to do takedown notice again, but this is, again, a quick and cost-effective way of doing things. Finally, I cannot recommend strongly enough the use of watching services. You can sign up for watching services through your law firm or through third-party providers. And they basically will let you know anytime that someone is trying to file a trademark application for something close to your mark or close to your field, and certain watching services can also include things like domain names and business names and other business-related uses. It's an incredible way of learning about issues early so you can craft a response quickly and early, and often the quicker and sooner you can notify a potential infringer before they go too deep down the road investing their own money in the infringement, you can resolve it quicker. We have definitely found the earlier you let a potential infringer know of the infringement, the more likely it is to be resolved early on. Now, there is the reverse issue, of course, that if you consistently decide not to do anything with the notices you're getting from the watching service, well, then you're basically saying, we're on notice of these potential infringements, we're not doing anything about it, and you both have the potential for the don't enforce it and lose it possibility, as well as against the individual defendant, the potential for statute of limitations or latches issues where you let it go on too long after having notice. And we discussed, obviously, non-enforcement can be very damaging to your brand. But the way I would say it is anyone serious about protecting their brand should seriously consider such a service, because if you're serious about your brand, you're most likely going to want to know when someone is potentially infringing or putting in a trademark registration for something close so that you can protect it. So again, I very highly recommend such services. So thank you very much. Thank you for joining me for Frenemies Season 2, Episode 2. Feel free to reach out to me or any of my colleagues if you have any more questions or any comments or questions on the information on the content covered. And of course, please tune in for other episodes in the series. And you can currently see the prior episodes all available on McGuireWoods.com. Thank you.